Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. I've been privileged to know some really great attorneys, really great trial attorneys during the course of my career as an attorney. And one of the first really great trial attorneys that I met was a gentleman by the name of John Schamberg. Now, John Schamberg started practicing in the 1950s, and that was back before the discovery rules were written in the way that they are now, and where it was really trial by ambush. You didn't know what the other guy had in his file till you got to court, and you'd best be pretty fast on your feet once you got there. John Schamberg taught me a lot, and he was a great communicator. He made a connection with every juror in the room. You could watch him. He used his voice. He played it like a violin. It went up, it went down, it got loud, and a lot of times it got soft. But whatever it did, it was always communicating a message to that jury, and he did it great. And he did it because, as a trial lawyer who was trying to get money for somebody who had been hurt, he needed to play on the jurors' emotions. And that's what he did. That is effectively what most trial lawyers do. And there's no shame in that. But what's interesting about that is that a lot of times trial lawyers who are really good trial lawyers, when they get into trial and they start putting stuff on for a jury, you couldn't beat them. But when they are arguing emotion in front of a judge, they argue emotion, not emotion. They use emotion in the same way that they would use it in front of a jury, and it just doesn't work. So today I am responding to a subscriber's request to critique Mr. Owen's motion to suppress, his closing argument on that motion. And he starts off pretty slow. Let's take a listen.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession.
Really? You're kidding me. They're trying to get a confession. First of all, starting off with what you've already stipulated to wastes the judge's time. You need to focus on the issue that's properly before the court. You don't want to waste his time. Judges hate it when you waste their time. They have other things to do. Second of all, telling the judge what he already knows, that the purpose of police interrogations is to solve crimes and get confessions, also doesn't advance the ball. But what he's working up to here, and I think you'll see that in a moment, is an emotional argument. Let's watch.
The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you.
Now, if you are like me, you are probably wondering, what in the world are we talking about here with regard to a murder weapon? whoa, wait a minute. Who is her co-defendant and what did he say? And then you realize, well, these are just examples of the way that police lie to suspects. Now, you may not like that. You may think that it's an unfair advantage given to the police. You may think that it's not right. You may think that it's morally objectionable. And you might be right on a lot of those things, but that's the way the law is structured. Now, when you're arguing something like this to a judge and you come in with this kind of argument, it is unrealistic in the extreme to think that the judge is going to go, man, I never thought of that. It's unfair. Wow, I'm just going to throw out 100 years of Supreme Court precedent, and we're going to put these police officers back on the straight and narrow, because that is not going to happen. And again, I hate to beat the same drum, but he's wasting the court's time.
All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental.
I have never heard anybody tell me, or I've never seen it in any case that I've ever read, that you cannot deceive a client or deceive a suspect prior to the Miranda warnings. There is no guarantee of veritas prior to the giving of the Miranda warning. Now, even afterwards, of course, they can always use deception afterwards because the client's been warned, but the long and short of it is that there's absolutely nothing that requires a police officer not to subtly deceive a suspect prior to going into the Miranda warnings. Now, certainly it would be okay if the police were in possession of a bag marked evidence and there was a big gun in there and they came in and they dropped it on the table in the room and said something to the effect of, we need to give you your Miranda rights, because I guarantee you the suspect is looking at the gun and he's probably not even hearing, I need to give you your Miranda rights. There are lots of times when that kind of thing happens. Police use all manner of trickery, both before and after. And so this idea that you can't deceive them prior, I don't believe has any foundation in the case law. But I could be wrong because, like I said, I've not read every case in the country on that, but it doesn't sound right to me.
You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that should be allowed or is allowed. There's nowhere in the law that should be allowed. It's actually illegal.
Keep in mind, this is what he's saying. The police came in and said, we have to talk to you. We have to talk to you. Now, There's only one way to understand that statement, and that statement is the police are going to talk to Sarah Boone. If you got an English teacher to diagram out that sentence, that's what it would say, that's what it would mean. What he is asserting that that statement means is you, Sarah Boone, have to talk to the police. But that is not what the detective said. Now, that may be a subtle thing. It may be a play on words as far as what's allowed. It may be deceptive, but it's not unlawful and it's not illegal. And his statements to that effect just don't measure up. They miss the mark completely.
That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of "we have to read you the rights" was made before "we have to talk to you." So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses.
Oh, please. Brought there under false pretenses. You ride to the station with a couple of detectives. You get put into an interview room. One detective, by your own admission, has a firearm on their hip, and they're telling you that you have to talk to that they have to talk to you. And they're telling you that they have to talk to you. No one with an IQ over room temperature in degrees Celsius would believe that they were there for a tea party or something else. Sarah Boone knew exactly why she was there. She knew exactly what she was planning on doing. She was going to weave this little tapestry of, I didn't know the gun was loaded. I didn't know he was in the suitcase. I thought he got out. I went upstairs. I went to bed. I took a nap. I woke up and I couldn't find him. That's what that was always what she was going to do in that interview room. Because, like many people who do this kind of thing, she thought she could outwit the police and convince them that it was all just a tragic accident, when in fact it was probably, honestly, part of her plan to begin with. Which kind of makes me wonder how smart Jorge was when he jumped into the suitcase to begin with. What kind of rational man puts himself in a suitcase with a crazy person who's telling them that, we're playing hide and seek? For that matter, what person above the age of 12 plays hide and seek anymore? Anyway, the closing argument on this particular motion was not his finest hour. He had a very, very difficult row to hoe. He didn't really do much to advance an argument that this was somehow involuntary, that her will was overcome, that she was browbeaten into confessing. That didn't happen. She spun a yarn because she thought she was smarter than the police. And like the majority of people who go in there saying, I bet I can tell some really credible lies, she couldn't. She just couldn't. So I give him an A for effort. I give him a C for logical argument. Because when he's saying these things, that's unlawful, that's improper, you will notice he didn't talk about any of the cases. When lawyers argue motions, normally when they come to a thing that is really important, like that's unlawful, they say, and you can find that rule in Smith versus Jones or State versus Erickson or wherever it might be, and they give the court the cite. so that the court then has to go back and read that case before they can actually rule on the motion, unless, of course, that stuff's already in their pleadings, but I doubt very seriously because, again, you want to illustrate to the court what you think the most important cases are that support your argument. And if you're not talking cases, if all you're talking is facts and coulda, woulda, shoulda, it really ought to be this way, it's so unfair, then you are not advancing the ball for your client, and you're destined to lose. And indeed, that is exactly what happened here. They lost the motion to suppress because they didn't establish that this was an involuntary confession. And I think anybody who has followed this case for more than a day would recognize that. And certainly anybody who listened to her direct testimony in this case would think the same thing. So that's what I have for you today. Like I said, this was in response to somebody asking me to do it. Hopefully you found this interesting, entertaining, and if you would, I'd love it if you'd leave a like, a subscribe, whatever you'd like to do. If you have any questions, drop them in the comments down below. And if you want, you can email me at the address above. Thanks again for watching. Do a kindness for somebody today. Make the world a better place. Then come on back here tomorrow and we'll talk about something else. Hey, as I said at the beginning, none of what I said is legal advice. But let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.